Um,
Yeah, it just went live on YouTube now.
Right. Okay. My name is Paul Nielsen. I've been appointed as the appeals hearing officer for this matter involving, I want to say it's 6 Blue Bison versus Alpine City. And really, this is a fairly informal hearing process. We don't follow the same strictures that you would in court, but we will try to maintain decorum, obviously, and I'm not concerned with the folks who are participating if that's going to be an issue. We'll try to follow a format. Counsel for both the city and the appellant and I had a conversation in the recent past about how we would structure this. We're going to give about 30 minutes each for each side to present its case. And then from there, there will be some, I guess, less structured interaction with ultimately the appellant having the final say. But I see this as sort of more of a free exchange a conversation once we get through the parties' presentations. And just by way of background, I am senior city attorney with Salt Lake City. I've been there for going on 13 years. I worked at Salt Lake County prior to that, and years before that, I worked in private practice in New Jersey, where I represented both developers and municipalities. So I don't have any particular biases. I dislike everybody equally. I can appreciate the perspectives of all of the parties, and also I'm a property owner, so I appreciate the perspective of the citizens who are concerned about the application that's been presented. That being said, my role here is to determine if there was a mistake made by Alpine City. As noted by Mr. Guyman in his brief, the city does have a presumption of correctness in their decision, and it is the appellant's burden to prove that the decision by the city council was arbitrary, capricious, or illegal. And I should say at this point, it's not just a decision by the city council. We have 2 appeals. One appeal was filed in late 2019, and that's an appeal of a determination by the city's zoning administrator, Mr. Roy. And then we have the appeal of the city council's decision denying the amendment of a subdivision plat at its June 23rd, 2020 meeting. So that being said, my role is to hear the parties' positions, and if the appellant meets its burden of showing that the decision was arbitrary, capricious, or illegal, then I may fine for the appellant. If the appellant doesn't meet that burden, then the city's decision will be upheld. I'll have some questions along the way. We'll see how that goes, but at this point, if we could have counsel for the appellants introduce themselves and the parties. It looks like you're in a conference room at Strong and Hanny.
Yes, good early evening to everybody. Paul, thank you. Paxton, thank you. Graydon Jackson and Aaron Smith with Strong and Hanny for the appellant. We have a representative of our client, Jake Satterfield, who is present with us. We're trying to be socially responsible by wearing masks as the governor required. So if our words get muffled or anything, please let us know, and we'll do our best to speak clearly But thank you for your time this evening.
I can hear you clearly.
Okay, great.
Great. And I am Paxton Guyman. I am representing Alpine City in this matter, defending the land use decisions at issue. Before we get going too far, I wanted to see, I know that these Zoom conference calls have a screen sharing function. Paul, are you the one that's managing that, or is it someone at the city?
I have no idea.
Okay.
I don't know that I am considered the host on this. I would assume it's Alpine City.
I
So
think it
if
is
there's any-
Alpine City. So I don't
I'm
need
the
to share
host,
anything.
yeah.
Yeah, I don't need to share anything now, but when the time comes for my presentation, I will want to do some screen sharing and would like to have that function opened up for me to use. That's all.
Fair enough. With that being said, unless there are any sort of procedural concerns that anybody has, let's hear your presentation.
Paul, if I can just chip in, this is Austin Roy with the city. I'm hosting it, and so I've enabled it so that screen sharing, anyone can share their screen. So
Okay,
that
thank you,
feature
Austin.
should be enabled, okay?
Thank you very much. That being said, Mr. Jackson.
Yeah, thank you. By way of some context for what we're determining tonight, my client is a developer. I think that's clear to everybody, but we're not trying to hide from that fact. We are a developer. We own 2 parcels of property. The one on the Alpine side is the subject of these 2 appeals. And then directly across the border, we own property on the Draper side. While the 2 properties are next to each other, they are 2 separate developments. And so they are being developed separately. Both of these parcels have some history. Let me give just a little bit of that. First of all, with the Alpine parcel that is the subject of our discussion tonight. That is a piece of property that is on hillside. The topography of that property is a little bit difficult to work through as far as a developable parcel. Prior owners have made applications for the development of this parcel over a period of years, and that has spanned multiple mayors, multiple city council members. In prior applications, some of these same concerns that we will be talking about tonight have been raised. There is one that I will raise now because I think it gives some context as to why we're here. And that is the fact that this particular parcel is an orphan parcel. It doesn't have any access points unless you attach it to Lakeview Drive. Lakeview Drive on its own is a long non-conforming cul-de-sac. I think it's approximately 700 feet. So the prior application that was approved was also non-conforming, but at the time that it was approved, there was no choice but to allow that connection because the owner on the Draper side of the property was not the applicant, and the city of Draper was the one that owned that Draper parcel. On the Draper side, this piece of ground, I describe it as Hillside Park. And there are many people who live in the area in Alpine who probably unknowingly trespass there on a regular basis to ride their 4-wheelers and motorcycles and go hiking and bike riding. There's an extensive amount of traffic going on and off of that parcel right now. Jeeps and Land Rovers and those kind of vehicles. This is been used by neighbors in the area. Again, I don't think they knew that they were trespassing, but that's the piece of property that we're talking about. My client purchased that property from Draper City, what's been a couple of years ago now, and has worked through the application process on both sides. Just by way of further context.
May I interject for just one moment? I promise, Graydon, I won't interrupt you very often. Can I interject for just one thing? And Your Honor, it's because this is a review of the record, right?
Right.
To review the record. And I don't want to let everybody go too far off the path, because now we're talking about things that just aren't in the record.
If we are talking about things that are outside of the record, then we need to curtail that. I'm assuming that Mr. Guyman's correct that that's outside of the record. There was a lot of stuff provided, but there are things that some of the background that I'm not sure necessarily was provided. So if you can confirm to me whether that's in the record.
So I'm not trying to go outside the record. There were some allegations made against my client that he was acting like a Trojan horse, that he was disguising the fact that he owned a parcel right across the border. And so I'm just trying to give some basic context. We are a developer. We're not trying to hide around anything. We have worked with Draper City on an application that has nothing to do with what we're talking about tonight. But Draper City, unlike Alpine, has allowed us a road to the border. And so I give that just by way of context. It has nothing else. I'll move on from this.
I appreciate it. Can I ask a question? You indicated that when the original subdivision plat was approved, there was no choice but to connect in the way that was shown on that original plat.
Yes.
Can you explain that? Why were you required, or why was your client required to? Was it connecting to Lakeview?
Lakeview Drive. So first of all, it wasn't my client who made that application, but a predecessor. Well, there were two. If you look at the topography, and I'm sure you have as part of the record, there are significant slopes on mountainous areas that comprise these 34 acres. And so absent fairly extensive engineering, and I'll go into that later in my presentation, there's really no other way to get access but through either the connection where the road will come from Draper, or a connecting to Lakeview Drive. And so just kind of path of least resistance, those are the two most obvious connection points without blowing up half the mountain and putting extensive retaining walls. Does that answer your question, Paul?
Yeah. Yes.
Okay. All right. My client has and continues to want to work with both cities in the development of these two separate parcels. Because when the original plat was approved, the Draper side was owned by the city of Draper. The reason for these applications, Paul, is because now we owned the other side. And so some of these concerns that we'll talk about in just a second couldn't have been resolved with the original plat that was approved, but because of our ownership of the other side, could be resolved. So as you mentioned, there are two applications that are currently on appeal. The first application sought to put a through access to Draper City. So this through access would connect to where Draper is now allowing us to have a road that meets at the Alpine border. That application was made with these two good cause elements. The first is this long cul-de-sac, and it's been extensively briefed, but this long cul-de-sac problem or violation of the ordinance, the exception, existed and exists with the current plat. because of the length of the road of Lakeview Drive that I just described, and then the length of the meandering road through the subdivision, the only way to cure that would be to have a second access point. And so by allowing a through road, we would solve for that exception. The second good cause element was Alpine has an urban, a wildland urban interface ordinance that requires that in this particular zone, there be two access points, and there's only one. And so we would actually solve for that Alpine ordinance exception that was on the original plat. And so you've read a lot about safety, along with getting rid of the issue with the long cul-de-sac. This development became safer because emergency vehicles could get through on the Alpine side as well as on the Draper side. Now, as part of that application, the city wanted my client to do a number of things, which it did. It did a traffic impact study, and that came back, and that's a matter of, it's in the record, with no significant or material issues. Geological hazard screening assessment was done at the request of the city. Again, that came back with no issues. Debris flow hazard assessment, that came back with no issues. We did a drainage study. Again, no material issues. We did a hydrology study at the request of the city. Again, no issues. Geotechnical investigations were done. Again, no material issues. And then there was extensive conversation about the road width and grade. Now, I mentioned the topography of this particular subdivision. So we've got, this is not flat land where you can just put a road wherever you want to. There are some very steep slopes and some challenges. And so there was significant discussion with the city about the road width and the grade. That application, as we all know, was denied. And the reason for the denial was the statement that it did not conform with the general plan. And that denial was noticed for appeal.
If I could hold you there for
Yeah.
a couple of questions. First of all, you've characterized it as being denied. Ultimately, the city council has the final say on a subdivision amendment, right?
It does, yes.
Okay. There are a lot of procedural things that are in my head on this matter, and I'm going to need everybody's help to get through these. I'm trying to figure out how to characterize what that decision is. Right now in my mind, it's an administrative decision, not necessarily a final decision on a land use application, but it is an administrative decision. I'm just kind of bookmarking that right now because I think it's important. The other question, actually, that wasn't really a question. It was more of an editorial. The question I have as far as the issue with the cul-de-sac, we're talking about a really long cul-de-sac. Is the concern there that it violates an ordinance, or is the concern there that there's a hydrant pressurization concern, or why are we concerned about the length of a cul-de-sac?
Well, I think as I understand the city's position, and Paxton can probably address this as well in his presentation, but the city wants to see a cul-de-sac no longer than 450 feet for ingress and egress in the event of an evacuation, especially where we've got mountainous terrain. And second, for emergency vehicles. Fire trucks, police cars getting up and down the road. Now the pressurized issue on the fire hydrant that was raised, I don't see that as necessarily an issue. There are fire hydrants that go up canyons and go up roads all the time. That was raised by the city. I did not see that as I didn't see that as a reason to not approve this. I just saw that as an issue that would need to be considered during construction.
Does it matter if we call it a cul-de-sac? And we'll have these same conversations with Mr. Guyman, but does it matter if we call it a cul-de-sac or just a dead end road or something else?
I don't think it matters.
Okay, continue, sorry.
Okay. So on our second application, so we noticed it with appeal, on appeal. I had a conversation with David Church at the time, and we both agreed to continue that appeal to see if we could work with the city on a solution. That is something that doesn't happen very much in our day and age, unfortunately, but it happened here. So my client and the city got together. They spent hours working through issues, trying to address concerns of both sides, and came up with what David Church called a compromise application. I think that's the right label to give it. It was a compromise application, and it addressed a number of good cause elements. First of all, it increased safety to the Plat by allowing emergency access from both directions, but it also addressed the city's concern on the general plan. So it was not a through road into Draper. That compromise application allowed for an emergency gate that could be siren activated and would allow emergency vehicles in the event of a fire on the mountainside to come from the Draper side, or emergency vehicles to come from the Alpine side. And so it increased the safety in the area, and it was consistent with the general plan. The second was this long cul-de-sac issue. It addressed that particular issue. There was this emergency access point that was available for the benefit of the citizens in that area. And so it made that long cul-de-sac exception. It addressed that particular concern. Now, on the wildland urban interface, that Alpine statute does say that there has to be 2 access points. Now, they have no trouble violating that by restricting us right now, but that statute, we think, should be followed. Now, our next good cause element on that second application was that although we didn't have 2 public accesses, we did have 2 access points. And so if there were a fire or something on the mountainside, then citizens could get to safety 2 different ways. And then finally, continuing to work with the city, the proposal was to give the city a lot, because in that particular area, there is a drainage problem that the city is trying to address. And so a lot was going to be given to the city. This, Paul, was a win-win-win. Staff was completely on board. It didn't violate the general plan. This was everybody giving people high fives, okay? The developers in the city had worked together. As we know, that was set for a meeting before the city council, and it was denied in a way that I'll talk through later. But number 1, for a violation of the general plan. Number 2, too long of a cul-de-sac. And 3, that there was a previously approved and developed or previously approved plat that the contractor could, or the developer could use. Let me take those in turn. The general plan. Paul, I've studied that document. It was drafted in 2007 by its own by its own letter, it states that it is a general plan. It was not to prescribe everything that would happen in development. It anticipated that there would be future development. By its own drafting, it stated that it should be reconsidered after 5 years. It was 13 years old when the city turned to it for a reason to deny our application. The general plan has all sorts of exception and condition language. We've cited that in our brief. I won't go into that further because I know you've read everything. But it was a general plan.
I also read through that 2007 master plan, so
Okay, great.
I know what's in there.
Okay, thank you. So the city harps on the fact, argues the fact that, hey, we've got 3 gateway entrances in and out of the city. This is not a matter of the record, but just I think you can take judicial notice of this. We checked yesterday. There are 14 access points from Alpine to other cities. And so if the city was so concerned with access points and not allowing us any access point, well, they sure made a bunch of exceptions before. And Paul, that makes sense. It makes sense because there has been a lot of development in that area since that plan was adopted back in 2007. So there's no mandatory language in there. There's nothing that prohibits another connection point. There's nothing that prohibits an emergency access like we applied for in our second application. So maybe good enough there. I can.
Let me interrupt you for a second again. I'm sorry. This doesn't count against your time. So the master plan talks about the protection of the 3 gateways.
Yeah.
But I didn't see anywhere in the master plan where it defines what a gateway is, and I'm not sure that that's defined in the code. Is it your position that any sort of a connection to another city is considered a gateway?
I didn't see a definition of gateway, but I don't think so. What I saw was that those were major, 4-lane roads or something like that would, and don't keep me to that. I'm just throwing that out as an example, a hypothetical, that those were major access points. These, what we're talking about, are connections through neighborhoods, which is what this would have been. So I didn't see this as a prohibition. All right, let's talk about the long cul-de-sac. I've read Paxton's brief, which was very well done. He's a great lawyer and a good friend. What I saw, the struggle that I think he's trying to express with the city is he is saying, look, you can't get 2 things at once. You can't say that you are a cul-de-sac where we've got this violation of the ordinance and your road will go too long, while at the same time claiming in the other breath that you are an open access point as it relates to our second application. Paul, I don't see the conflict. We are both. We are. We are saying that we are a cul-de-sac. We're expanding from 4 lots to 8 lots. I don't think anybody is arguing density over a 34 acre parcel to have 8 lots. And so we are saying that there is a road that will have a cul-de-sac feel. That was the compromise. That is how the city wanted it. That is how we tailor-made it, because the city came to us and said, we want a cul-de-sac-like feel. We don't want people blazing through there on their Jeeps. And so, Paul, that was the compromise. And so we had the cul-de-sac We did not, if you take where the development of homes will be, it is no longer than what is currently approved. Now, of course, the road goes a little bit longer because of how it's designed, but there are no building structures. But that was what the city wanted. They wanted a cul-de-sac-like feel. Now, we identified within that application that stub road, and there was significant discussion with the city about the width of the road, about what materials it had to be made of. They were concerned that if it looked like a road, and so we negotiated on that point. We talked extensively about the gate, that it would be siren activated, that people would not mistake it for a Draper access, that signage would be put on saying no Draper access. And from the Draper side, we volunteered that we would put no Alpine access, so that nobody would be confused. But Paul, that was the compromise. That was what they asked, and that's what we did. And so to say that, it's like kettle corn. I mean, it's sweet and salty. It was designed that way, so that it addressed both issues. Now, the next issue was that a property owner could still develop under the existing plat. Now, Paul, there's a little bit of historical context. Let me just race through it. I mentioned the topography. If you were to loop a road, and if you were to look at this parcel, if you were to loop a road, you would have to literally take down several mountainsides. And at the time that those were historically applied for, the neighbors at that time were up in arms because it would show an amazing scrape on the mountain. It would create a hazard because you'd have to retain, and it would be so prohibitively expensive. And so I guess what they're saying is technically you could do this, you could loop something around, but it's impossible, and they know it. And it's been tried by previous applicants where they have applied and said, hey, I guess we'll just put a bunch of retention, and the neighbors are like, and take our beautiful mountainside away? We don't want a scrape on the side of the mountain, and we don't want all that retention to show. So it's as if they're tying it to this long cul-de-sac issue and saying, hey, you're creating this problem. I think we're actually solving for it. So anyway, enough probably on that. Let me go to public clamor. You emailed Paxton to me today saying you had listened to the hearing. So I'm sure you've made your own assessment of the public clamor that was there. Let me just offer a couple of comments. We're in the middle of a pandemic, and our good mayor decided that what better opportunity should we have to meet with 200 of our closest friends than to get a school hall reserved and pack everybody in there in the middle of a pandemic. He felt that it was so important to have all those citizens there to observe it. The other day, my kids came home from a party. I have teenage kids, and I'm just about to fall asleep, and all of a sudden they say, oh, it's fine. Yeah, the cop showed up. And, I sat up in bed and I said, the cop showed up. Help me understand that. Well, the cop showed up. I mean, they haul a guy off. We have people standing up. I think Paxton did an awesome job of describing what happened at his church service on Sunday, and just kind of took that description and applied it to the Alpine City residents. We have a very different view of how those residents behaved. Jake Satterfield is here. He can tell you of the personal threats that he received by individuals who were in the crowd. I'm not here to say that he left there shaking in his boots, but he was unsettled by personal threats that continued into the parking lot. We had people standing. For what purpose? I mean, if it was as Paxton described, where they had politely identified two people to speak, then there was no need for demonstrations. They had them, and frankly, we went in there with an application from the staff, a report from the staff that said, and this is Exhibit 2 to our memo, we recommend approval of the Plat Amendment. The Plat Amendment now proposes a cul-de-sac with a fire access connection, which meets the city's general plan. This is from the staff. This is the compromise that we all came to. Then they've got, as we've briefed, model motions. Now, Paxton has said that they had a sample motion to deny. I've looked at that exhibit 5 different times. It only has a motion to approve. It has no sample motion to deny. I think they didn't bother with a sample motion to deny because it was a compromise. Everybody was going in with the understanding that that would be improved, and it had the endorsement of the staff. We also have the endorsement of the fire chief. That exhibit is also a part of our brief. He said, in order to approve these lots, this connection is required due to the length of the road with the relationship of the existing length of Lakeview Drive. Again, Paul, we solve for that exception to the ordinance. That's part of our good cause. So, look, I think I'm over on my time, although I have answered some questions, so maybe you'll forgive me. I would like to reserve the opportunity to offer some concluding comments. I acknowledge the standard that you set forth as you began, but I think the question that I will answer is, why did they vote no? If you've got something that meets the general plan, if you've got something that addresses the long cul-de-sac issue, if you've got something that will address the Alpine City Ordinance of the wildland urban interface, if you've got something that will allow for a safer Plat Amendment, then the only, I guess, let me let that simmer. I think I've taken 30 minutes. I would reserve a couple of minutes later if that's okay.
Yeah, that's fine. Let me ask you some questions. The reason that you require this road that connects to Draper City is because of the wildlands ordinance that requires 2 access points or 2 connections.
That's one of the reasons, yes.
What are the other reasons?
Well, for the safety of the residents.
In case there's a fire that they would need to
Evacuate. Yeah.
Is this road that your client is proposing to construct with an amended plat, would that be a private road?
So
or are these being dedicated to the city?
So the road up through the cul-de-sac would be all city roads. They'd be public roads. The city wanted what we've called the stub road. So what would connect from the cul-de-sac to the Draper side, they wanted that to be a private road with a gate on it. That was the compromise we came to with the city. So that was at their request that we did that.
So you've mentioned, and I don't doubt this, it would be hard to fathom that in 13 years, there have been developments within Alpine City that didn't include the creation of roads that weren't shown. I'm probably saying this in a negative way. It's hard for me to believe that there have been developments with new roads that complied with the master plan. That every new development since 2007 has been constructed with new roads in accordance with those roads being shown on the master plan. And you've pointed that out. Are there any examples? I mean, again, I don't think it's hard to believe, but are there any specific examples that you can point to?
Not
Sure.
in the record.
What's that?
Not in the record.
Well, we've pointed out a number of them. They were raised with staff.
I understand, Mr. Guyman. It was the argument was made. I'm wondering if he has any examples to support the argument.
Right.
Well, we've cited those in our brief.
Okay. Here's the tricky one for me. If I were to find that the city acted arbitrarily and capriciously or illegally, we've got this Baker versus Park City case that's been cited, and the standard there, which points to the statute, is whether there's good cause. And I think that this is a bit of a tricky thing to get past, because the court in Baker said that even if they find good cause, even if Park City in that case found good cause to approve the subdivision amendment, it's still a discretionary thing as to whether they have to approve that. So if I were to find that I'm trying to connect arbitrary and capricious with this good cause standard, and the fact that the Court of Appeals in the Baker case said that it's a very low bar to meet good cause, and they don't even have to approve it if they find good cause.
Well, I think what Baker stands for is certainly a comment that is very favorable to the city, as you mentioned, but it still points back to the standard. You have to have a reason. You have to have a reason. I mean, otherwise, by definition, it's arbitrary and capricious. I mean, if they have no reason, then they're just doing it because they want to stick it to us.
Well, they did. They gave reasons. They gave 3 reasons. And I'm not going to weigh right now, how credible I think those reasons are, but they gave reasons. And in the Baker case, it came down to there were folks in the community who said that this won't be compatible, and Park City said, yeah, we don't think it's going to be compatible, which is an extremely low bar.
Well,
I'm trying to figure out how to get past Baker versus Park City if I were to find that the decision was arbitrary, capricious, or illegal.
Well, so if you went with any one of those reasons, obviously you as a hearing officer have to make some judgment as to whether those reasons that they threw out were arbitrary and capricious. And they were. I mean, to say the general plan, when you've got staff that studied this, says it's compliant with our general plan. Obviously, that's arbitrary and capricious to throw that out and say, well, our basis is that it doesn't comport with the general plan. And next, if you say along cul-de-sac, well, okay, Lakeview Drive, the current subdivision is along cul-de-sac as it's currently. So obviously, if that is your basis, for the same reason that the current Plat has been accepted that hey, we're going to deny it, even though the current one violates in that exact same way. That's arbitrary and capricious.
So just let me be clear, the approved plat, and it was approved in 2017?
That's right. Is that right? 2017. Yeah, I think that's right.
2017. So the plat that was approved in 2017 depicts a longer cul-de-sac than what is proposed in the amended plat. Am I saying that right?
No, I don't think it's longer. Or is it
Is it the
longer?
same?
Less direct, actually.
Yeah, it is less direct. Okay, so I'm sorry for letting me clarify. It is longer than what is currently being applied for.
I thought I had read that somewhere in the
Yeah.
in the documents. Okay. Now I want to come back to this sort of procedural issue I identified up front. So we have the city zoning administrator indicating that he would not remove some red line comments on the proposed amended plat, the initial one that was submitted in 2019. And that's as far as that got. You filed the appeal, and then things were put on hold while the alternative plan ran its course. So hypothetically, if I were to find that, because I don't think, and correct me if I'm wrong, but I don't think that I'm looking at a good cause standard on that decision, because it's not a final decision. I'll let Paxton respond to this, but hypothetically, if I were to find that were arbitrary and capricious, but I found that there was good cause on the second appeal, how does this thing play out?
Well, I think you can independently reverse either decision. I think you should reverse both. But I think you can independently reverse one and not the other.
Okay. I might have some more questions for you. Oh, I do have one. Does your client own all of the subdivision?
Yes. Yes.
Okay,
All the
so
34 acres.
I believe there was an argument. It may have come up in something that David Church had put in one of the city's position pieces, but there is this. It's a different standard for an amendment to a subdivision plat. That different standard doesn't only apply to amendments; it also applies to vacations. Has there been any discussion about vacating the plat? I'll just leave it there. Has there been any discussion about vacating the plat or filing, somehow extracting what's there and then starting over?
No, but that's certainly something that we've contemplated.
Okay. Thanks. Let's let Mr. Guyman give us the city's position.
Well, thank you. Thank you, council. Thank you, Mr. Nilsson. By the way, do you want me to call you Your Honor, Paul, Mr. Nilsson? You have a preference?
You just call me whatever you want. It's awkward. Anything, just call me Paul.
All right. Well, thank you. I appreciate your time this evening. I think we need to try to stick to the relevant information and the applicable standard. And I say that with no disrespect to Mr. Jackson, but much of what he was saying was not actually tuned in to the applicable standard. And so let's talk about what we're reviewing here. What we're reviewing is the decision of the city council to deny a plat amendment application. That is absolutely not the same as the review of a decision to approve a plat. They are very, very different. And the Baker case highlights that decision. So Paul, you mentioned, how do you get past the Baker case? Really, you cannot. And I want to highlight this. If this was an application to approve a subdivision in the first instance, and it was a plat application that complied with all of the city ordinances, that would be very hard for the city to deny an original plat approval application if it complied with the ordinances. But that's not what we have here. What we have here is an application to amend an existing recorded subdivision plat. And by statute, not just the Baker case, but the statute says the land use authority may amend or vacate a plat if it finds there's good cause to do so. That's the standard. That governs, that's where the analysis starts, and it governs everything, and it ends there as well. If the city did not find good cause in its discretion to amend the plat, it didn't have to. What's interesting from the Baker decision, though, is that even if the city found good cause to amend the plat, it's still a discretionary item. In other words, it doesn't use the mandatory shall language in the statute. And actually, this might be a good point for me to do a screen share just to show you what I'm talking about. And this might help.
And while you're doing that, I'm gonna show my cards here a little bit.
Sure.
I'm not a big fan of the Baker decision.
Okay.
And I'm not a fan of the way that the legislature drafted Section 609, and I'm going to tell you why. I don't think they did a very good job. I don't think the legislature did a very good job of drafting this in the first place. I don't think that the court did a very good job. And here's the thing: I recognize I don't get to decide whether Baker's good law, but that's not to say I don't think that it's infallible. Because 609 subsection 1 says the land use authority may approve the vacation or amendment of a plat, right?
Right.
If you go down to subsection 4, we also have the word may appear, and it says an amended plat may not be submitted to the county recorder for recording unless it is signed by the land use authority and signed, acknowledged, and dedicated by each owner of
Right.
record. So if may is the critical word in this statute, might also recording be permissive, discretionary, and whose discretion is it?
Yeah, let's talk about that.
I'm playing a semantic game here because I think that what the legislature intended was shall and shall not, but they didn't craft this very artfully. And we both know that when the legislature gets land use legislation, it comes from a joint effort usually of the cities and the developers, and sometimes we get things wrong. So we have may appearing in subsection 4 here that says may not be submitted. And so if I were to take the Baker Court's decision to its logical extreme, I think 6 Blue Bison could go into the county recorder's office and say, well, we may not, but we also may. It's a discretionary thing. We don't have to have the land use authority sign this.
Yeah, but there's a difference between using may in a permissive sense and using may in a prohibitory sense. So down below in 10.9A 609, where it says an amended plat may not be submitted.
I think they meant shall not. I think they meant shall not because may not is it's still discretionary. May is a discretionary word.
In the abstract, it is, but not when it's prohibiting something. And anyway, can you see my screen, by the way, Paul? Is it screen sharing?
I can, yes.
Okay. So you see up here, it says the land use authority may approve the vacation or amendment of a plat if the land use authority finds that there is good cause. Now, I'm going to show a different screen share because you've indicated that you think the legislature should have used the word shall.
Yep.
Can you see this statute now? Can you see the new one, 10.9A 603 on the screen?
Mm-hmm.
Okay. So down here,
Shall.
the legislature showed that it knows how to use the word shall. Here it says if the plat, and this is what I was talking about earlier, if you're doing an original plat approval application, not an amendment, but just an original application for plat approval, if the plat conforms to the municipality's ordinances, the municipality shall approve the plat. The point there is I think we have to at least assume that the legislature knew which words it was using when it chose to discuss shall versus may in the land use context. The statute that governs plat amendments clearly uses the word may.
And
And
that's part of the whole statutory construction exercise that the courts are supposed to go through. They're supposed to
Right.
first start with the point that the legislature used these words advisedly, but also the next step is make sure that doing so wouldn't lead to absurd results.
Right.
And I'm not here to. I'm really more airing grievances than I am saying that I
Okay.
think I have more authority than the state legislature or the Utah Court of Appeals.
Okay.
But to the extent that this is a very contentious matter, and there is a party that chooses to appeal this, it wouldn't hurt my feelings if somebody were to ask the court to get some clarity on this, particularly in light of the fact that this is an administrative decision. And we have the Baker Court saying that this is discretionary. But if you look at Draper versus Harmon City, there's a really good discussion there about the fact that administrative decisions are enforcement and application of the law, and it's those legislative decisions that are discretionary. So I think that there's a hole here, and it's not my place to fix it here tonight. And believe me, I'm not counting this against your time.
Okay.
But going through this exercise, if you can't tell, it's something that I think is it should be concerning to people who have to deal with these statutes.
Fair enough. That's fair.
Continue.
Well, I think we probably beat that horse enough, right? We've sort of shared our competing views, but I think both of us as officers of the court, as people who are professionals in this industry, are still stuck with the state of existing law. And the state of existing law is the Baker decision is governing case law, and the statute reads as it reads, which seems to suggest that it's not a mandatory approval. There's still some level of discretion. And in fact, that's what Baker said. Even if there's good cause, there's some level of discretion as to whether the city chooses to approve or not the Plat amendment. Now,
Paxton, I think you're still sharing your screen, and I have a really important question. Is that you skiing on your desktop?
Oh my goodness, you're not supposed to see that. Yes, that is me. That's not what I meant to show you.
All right.
That's up in Canada, by the way. Okay, let's get back to this. The existing plat approved a couple of years ago. It's for a 4-lot subdivision with a private driveway access, not a public road, a private shared driveway to 4 lots. That's what has already been approved. That's the state of entitlements right now. Blue Bison came in and said, we want to amend that. We want to amend it to provide for 8 lots, not 4, and a public road, not a private driveway. Those are significant changes. They impose new burdens on the city to maintain, snowplow, and manage a public road rather than a private driveway. Now, what's interesting here, just to put this in context, you can see the screen now with this overall map, correct? Alpine is the area in green. Draper is the area in gray. This little area right here where my mouse is circling is the area of land we're talking about, okay? You see that?
Yes.
Right there on the border. Now, I'm going to show you something else here that will, I think, put this in the right context. Okay. Can you now see this map with the red outline?
Yep.
Okay. This is the area covered by the plat. This is where they're asking to amend and put 8 lots here instead of 4. And to put this in context, if you'll see this little area that juts out on the bottom right-hand side of the square, take a note of where that sits next to Lakeview Drive. You see Lakeview Drive coming through here?
Yes.
And Hog Hollow. Okay. So this is the area where they want to amend the plat to go to 8 lots instead of 4. Here's the significance of that area. It's right next to where the developer wants to put over 400 residential units. Now they're saying this is the roadway here. You can see where my mouse is. This is where the connection point would go into the proposed 8-lot subdivision instead of a 4-lot subdivision. So clearly there's a lot at stake here. This is not just increasing the density from 4 lots to 8 lots. It's doing that, but it is also providing a gateway or an access point for a massive residential development to occur right next to Alpine. Those are the considerations.
Those are 400 lots
right. Over
in
400
Draper.
lots. In Draper. Yep. Right next to the boundary of Alpine. So that's clearly the context, the background of why this is such a significant decision. It's not just about Blue Bison's effort to get 4 more lots. It's about Blue Bison's effort to get 4 more lots and a connection road to develop over 400 new residential units. Now, the 2019 decision that was denied, you're right, the city zoning administrator at a staff level simply pulled the application because he said, and I've highlighted it here on the screen, the current Alpine City General Plan does not show a connection into Draper at this location. Now, counsel for the developer would have you think, well, it's just a general plan. It doesn't need to, you don't have to follow it all the time. You can, use it as you want and as a guidance post. But here, where you compare it against the applicable state statute, it is absolutely a mandatory requirement that it be a part of the general plan. So I
recognize what 406 says. This is something else that if this matter is appealed to the courts,
right.
While whoever does that, if that happens, while you're there, please get the courts to clarify what conforms to the current general plan means.
Okay. I think what they're trying to
That's my 2 wish list items. Thank you.
Okay, I'll work on that for you. Anyway, when you read the statute here, it says if the legislative body has adopted a general plan,
right,
no street, whether public or private, may be constructed or authorized until and unless it conforms to the current general plan.
Let's talk about what's happened over the last 13 years.
Okay, well, I want to put this in context.
Okay.
There's no question that cities cannot control what happens outside of their boundaries, right? Cities cannot. They can only control what's within the boundaries of their jurisdiction. But that's why it's so critically important that they decide where those connection points to other cities will occur. Because once they approve a road that connects to a different city, they lose all control over what might happen on the other side of that property line, how that connection road might be used, what sort of massive traffic demands might be generated by a 400+ unit new residential project neighboring your city boundary. That's why it's important to look at the general plan and say, okay, where did the general plan contemplate road connections would occur to other cities?
But that's not what 406 says. The 406 doesn't say that that no street connecting to another municipality can be constructed unless it conforms to the general plan. It says no street, park, or the public way. But generally, we're talking about street here. It says
I agree with you, Paul. I'm not arguing that. But in this case, this particular application to amend the plat involves a road that connects to a different city. So I'm sort of narrowing the analysis in to what's at play in this particular matter.
Okay.
So then when you look at the general plan, here it is. This is the Alpine City General Plan. This area that's highlighted in yellow is the area of the general plan we were just talking about. So the area outlined in red is the same as the area outlined in yellow here. And what's painfully obvious when you look at this general plan is that there is no road connection protruding through the boundaries to the neighboring municipality, none whatsoever. There are other places within the boundaries of Alpine City where road connections are shown, but in this area, there's absolutely none. No connecting road to a different city. And that's
remind me that yellow circle, is that there in the general plan or was that put in there?
I added that.
Okay,
I added that just to show you the area we're talking about.
All right.
Yeah, everything else is the same, but the yellow circle is my addition to show you the area that's in discussion.
Okay.
So this is what the city council members talked about when they said your application to approve a plat amendment is not consistent with the general plan because it shows a through road connecting out, going through our boundary to a neighboring municipality, to Draper City. Now let's go down through the rest of these slides and then I'll tie this back in. So let's see. The 2019 application was pulled by the city administrator because it had a through road that was not consistent with the general plan. So then they come back with a new proposal. And you heard Mr. Jackson call this the compromise. This was the compromise. This was the compromise. Well, you can call it a compromise all you want, but it's still nothing more and nothing less than a proposed amendment to an existing plat. It's a proposed plat amendment. And the standards governing plat amendments apply. Even if they were encouraged to present this to the city council as something that might be a good compromise solution, it still falls within the definition of a plat amendment application. And it's not something that they had the right to approval. It's not something where the statute said it shall be approved if it's a compromise. Call it what you will, it's still just an amendment to an existing plat, and there's ample discretion to deny it. Anyway, here's what they're saying. If you can see my mouse, they're saying that this road would come all the way up and there'd be this turnaround cul-de-sac right on the boundary line between Alpine and Draper City. There'd be this turnaround cul-de-sac. And on that boundary line, there would be an emergency access gate. That gate would basically be the way to go through to this side and connect to the Draper development. Now, there's been a lot said about the fact that the existing Lakeview Road already violates the code. And that may be true. The code in the city clearly says that cul-de-sac roads should not be more than 450 feet long. This apparently is already longer than that, but the development would extend it even further. And making a violation worse is still something the city council can decide, and its discretion is something they don't want to do. It's like expanding a non-conforming use. You're making an existing violation worse. Now, going to the next slide. Mr. Jackson said that the staff report only showed a positive recommendation. Well, that's just not true. The record is very clear. Here it is, an exact copy from our record, PDF 487 to 492.
I'm aware.
Okay, so the staff showed 4 different findings that could be made for why the plat amendment application should be denied. Going to the next one, the Planning Commission struggled mightily with this application. The Planning Commission, after 3 failed attempts to get a motion approved, finally got a motion approved, but only with 10 fairly difficult conditions and requirements that had to be met. Those are the 10 conditions. So they forwarded that on to the city council for consideration. And at the end of the day, the city council, after looking at all the evidence, they said, no, we're going to exercise our discretion. We are not going to approve the amendment, the proposed amendment to the plat application. And when you want to talk about the reasons why, when you want to talk about why did the city council deny this amendment to the plat, we don't need to look any further than the minutes themselves. And Paul, this is so important. You know, I do land use appeals. This is part of my practice. I do it a lot. I'm the land use appeals hearing officer in some of the cities here in town. I've seen these items, and very rarely, and I think you'll have to agree with this, very rarely do you find a record that is as robust as this one. Ordinarily, you don't find minutes that are so extensive and detailed with all the information. We are very fortunate because we now have here approved minutes. Nobody's disputing the validity of these minutes that have the actual words of the city council members themselves as to why they chose to deny the plat amendment.
Right, and a lot of those council members and the mayor, don't they say that we spent some time on the phone with the community members, and I believe the council member who made the motion, council member Smuin, indicated that she got into this because she wanted to be responsive to the community.
Right, right.
And how?
And there's nothing wrong with that.
Well, tell me the standard that points to. Making sure that the residents are happy. What standard does that point to?
Well, I would say that if that was the only basis, then that might not be sufficient. Okay, I want to be real candid here. If the only basis was public clamor, that might not be enough. But that's not what we have. The record makes it very clear there were several grounds supporting the decision to deny the application. Several. And if you look here, I'm going to start by the motion that was actually approved. 4 of the 5 city council members approved the motion to deny the application. Councilwoman Jessica Smuin, right here in the highlighted area in the center of the page, explains that the amendment would create one long road with only one public outlet, which is effectively a cul-de-sac longer than allowed by the letter and the spirit of the city code. she'd clearly gone to great length to understand the implications of this application. And she said, no, this is contrary to our view of the letter and spirit of the code. Number two, the emergency access road to Draper is not provided for as part of our general plan. Well, again, when we go back and look at the general plan, she's absolutely right. There's no emergency connection road. There's actually no road of any kind connecting to the neighboring municipality there. And as a city council member charged with weighing the policies and what's best for the city, she's entitled to say, we don't want a connection road to Draper there. Indeed, that's what 4 of the 5 city council members decided. We don't want a road connection in that part of our city property. We don't want a connecting road that goes to Draper in that location. And it was entirely within their discretion to make that decision. Why? Because they didn't find any good cause to grant the approval of the amendment. This entire record is devoid of any finding of good cause to approve the amendment. To the contrary, we have ample reasons expressed here for why they should deny it.
So I know I'm interrupting you a lot more than I did.
That's okay.
Appellant. Trust me, you'll get as much time as you need. The appellant in their supplemental brief, I believe it was in the supplemental brief, point to the fact that, actually maybe it was the appeal brief of the 2020 decision. They point to the fact, or they make the allegation that none of those 3 items were discussed by the council prior to that motion being made. And then isn't it interesting that immediately thereafter, Mr. Bateman, the attorney representing the neighbors, comes up with exactly the same reasons why they should deny it?
Yes. No, clearly she had done her homework. She had talked with people in the know. She'd informed herself as to what the appropriate standards are and the criteria she should be looking at. It's not in the record we don't know what sort of conversation she had with Brett Bateman, but they clearly saw things similarly, didn't they?
It looks identical. I'm not a conspiracy theorist, but it looks very, very similar.
Yeah, it's similar, although there's a few things that are different. I mean, Mr. Bateman here, and by the way, I'm not going to read all the highlighted language. As a courtesy to you, I've sent you a copy of this.
I've read it.
All of the language that's highlighted in yellow, in my view, reflects valid reasons that supported the decision to deny the application.
So 1, 2, and 3 are the good cause. That's your good cause right there.
Well, actually, no, that's the wrong standard. You don't need good cause to deny it. Remember, the statute says if the legislative body finds good cause, they may approve the amendment.
Understood.
We have no duty to find good cause to deny it. What we have to have is substantial evidence in the record to support the decision. And as you know, the case law has interpreted that standard to mean essentially any adequate evidence that would support a reasonable person to make that decision. So if there's
and the Baker court kind of got in the same place, right. But they noticed the same argument that, well, while Park City's talking about good cause to deny, it's really good cause to approve, and they don't even have to approve if they find good cause.
That's true. No, you're right about that. That's exactly the analysis. But the case law makes it pretty clear that if there's evidence in the record that would lead a reasonable person to reach the same decision, then hands off. We are to approve that decision. We're not to disturb it. We're not going to interfere with the authority of the city council if there is an evidentiary basis to support their decision. Let me just point something out to you here. Sure. When you look down at Jason Thielen's comments, I've highlighted them here at the top of page 6. He's saying he's leaning towards Jessica Smuin's motion because he doesn't like the long cul-de-sac. And then he says that he had a chance to sit down with the fire chief and discuss his concerns. He said the fire chief mentioned that a fire hydrant could break below and it would affect all of the water above. He said that when he looked at those issues, it went back to the fact that if there was not good cause, he didn't want to approve it. And here's, I think, the most telling thing. The very last sentence that's highlighted in yellow there. He said that was the direction he was leaning because he did not think the amended plat was an improvement to the original plat. That's exactly the kind of weighing of analysis that we want city council members to go through when they decide whether to amend a plat. You look at the original plat that was approved, the one that's already recorded. You look at the proposed amendment to the plat, and you try to decide, is it actually an improvement or not? And this
I'm going to
council-
interrupt you again, and I'm sorry.
Oh, go ahead.
You're talking about this analysis in deciding to amend a plat. What are the standards for amending a plat in Alpine City?
They're governed by the state code. It's the exact same. If
Right.
there is good cause to amend the plat, they may approve it. The
This
state
is
code-
this is where I'm going. There's nothing in the Alpine City Code about amending a plat.
the state code trumps it, even if there is. The state code is
Understand.
what governs.
State Code, I think it's 601, says that if a city doesn't adopt these provisions, then they're deemed to have adopted them. But still, how do we get to a decision? How do we know who makes the decision on an amended plat when you don't have any standards, you don't have any direction as to who the land use authority is on a plat amendment? I had a little bit of a panic going through this, where city code says that the appeals hearing officer determines whether the city code was applied correctly.
Right.
Either it's an interpretation or whether the city code was applied correctly. And I don't have a city code provision to look to as to whether it was applied correctly.
Well, you do, because the state code applies, right? The state code would supersede anything to the contrary anyway.
But the state code doesn't tell me who the land use authority is in this situation.
Yeah, that is an interesting question, isn't it? There's nothing that says in the state code that plat amendment applications shall be decided by the following bodies. You're right. You're right.
I'm hoping that staff is listening to me and thinking about a text amendment.
Yeah, so that's a good suggestion. We'll make sure we follow up on that. But as far as, the matter before us, the standard's quite clear. If the land use authority, which is the city council, if the land use authority finds good cause, they may choose to amend the plat, to approve the amendment. Here, if you go through and look at all the highlighted language in yellow, it's quite clear that there was a lot of thought that went into this. And there are ample reasons in the record to support the decision to deny that amendment. That's what happened. They denied the amendment. They didn't like it. They didn't think it was an improvement to the original plat. And for that, they were within their rights, and there's really no basis to disturb that decision. You know the standards well, so I'm not going to repeat them. But again, the city's decision is entitled to some deference. And when you look at this record, particularly these lengthy minutes, you'll see that there's a very strong record to support the decision. There's ample evidence in the record, and it can't be disturbed. If you have any other questions, Paul, I'm happy to answer them.
So I've asked a lot, and I'm sorry, but there are, as hopefully you get my sense, there are gaps here. There's a gap, I believe, in the state code. I believe that there's probably a gap in the Baker decision, and I think that there is a big gap in the Alpine City Code where you don't have any direction as to how you amend a plat or who makes that decision. So I don't know if I'm supposed to assume that because the Alpine City Code talks about final plats being approved by the city council, an amendment is essentially, I mean, it's an amendment to the final plat. It is, final plats are decided by the city council, but then I have this language in section 609 and the Baker case that say, yeah, but amendments are treated differently. It's a different thing. I'm wrestling with this. Hopefully you see that for me, this is not straightforward. I don't know, I'm not sure where I'm going with this. I mean, I have some ideas on some of the principles, but I'm struggling with the gaps.
Well, if there's additional questions or anything we can provide you in follow-up, I'm sure both sides will be happy to do that, to answer those questions.
So I'm going to ask you the question that I asked Mr. Jackson, and that is, if I grant the appeal on the 2019 decision, of Mr. Roy, but I find that there's a problem with the other. Where does this go? Does that mean that the 2019 application is approved and they have the
No.
connection road without a fire gate?
No, I'm so glad you brought this up. So you're referring to if you choose to say that it was unlawful or arbitrary or capricious for the city's zoning administrator to pull the application, the only thing you can do is say that that was the wrong decision to pull the application and reverse that decision, which means it just goes back and they start over. Then they go through the application process. They go through the same process that they ended up going through anyway.
That's probably not going to benefit anybody.
That doesn't benefit anybody. In fact, it just gets us back to what they already decided. They're not going to rule differently on the same issue. But I will say this, the 2019 decision, I don't think you can disturb that, because that was a call by the city's zoning administrator that application provided a through road. That was not a cul-de-sac. It was a different application. And this is important. That 2019 application provided for a full-on public through road, not a cul-de-sac, not an emergency gate, a through street all the way straight through to Draper. That was not contemplated by the city's general plan, and the zoning administrator properly pulled that out.
How do I reconcile that with the fact that the zoning administrator and the planning commission on the 2020 application determined that the new proposal that would have terminated that road for all intents and purposes at the fire gate was consistent with the master plan?
Well, that's where they were trying to come up with some sort of a hybrid solution here. And I think when you look at the planning commission's decision, they were only willing to forward a positive recommendation if all 10 of those conditions were met. And they haven't been met. Today, they haven't been met. There's no way to meet them.
I'm trying to figure out how I can reconcile and relate Mr. Roy's opinion on the 2020 application that the master plan, that this did conform to the master plan on the second application, but it didn't on the first. Because I have to rule on that appeal as well.
Yeah, here's how you do it. The 2019 decision was a clear-cut winner. He was absolutely within his rights because that was a different design. That design had a full-on public road going all the way through. No crash gate, no emergency access. That's not contemplated by the general plan, so he pulled it. The other one, the 2020.
But how is the 2020 road conforming to the plan if it's not shown on the plan either?
The 2020 application, which is a different design, the only decision you're reviewing on the 2020 application is the city council's decision to deny that application to amend it.
True.
You are not reviewing Austin Roy's decision on the 2020 application.
I recognize that, but I am reviewing his decision on the 2019 application.
Right.
And I can look to something like the 2020 application as a potential basis for an arbitrary and capricious decision. Because neither one of those roads is shown in the Alpine City plan.
Yeah, the real answer is what the city council decided. The city council said, we don't want a road there at all, whether it's an emergency gate or a through road.
Right, that's relevant to the 2020 decision. But as to the 2019 decision, I can look at Mr. Roy's opinion in the 2020 decision that road was consistent with the master plan.
Right, but then we're just chasing our tail in circles, right? Because you go back and you say, well, he shouldn't have pulled it. Now we're just going back to go through the same process all over again.
But I'm required to, I've been asked to rule on 2 appeals here.
Yep, that's true. That's true.
The outcome may ultimately be moot because then it goes to the planning commission and the city council, but I'm required to rule on 2 appeals here.
You're absolutely right.
And I hope you get the sense that I think that's problematic.
I can
the
sense
2019 decision is problematic.
Well, if you decide that the 2019 decision was in error, that it was arbitrary, capricious, or illegal, then we go back and tell him to not pull the application and let it go through the analysis, and then let the planning commission consider it. And then we let the city council make the final land use decision.
And the practical effect of that is that 6 Blue Bison sees that that's a dead end anyways.
Right.
Yeah, I mean, or maybe it's not, I don't know, but I'm required to rule on 2 appeals here. And I have significant concerns about the arbitrariness of Mr. Roy's 2019 decision.
Well, we trust that as you sort through this, if you need to read the briefs again or whatever it is, you'll come up with a sensible decision. That's all we can ask.
Mr. Jackson?
Yeah, let me hit on a couple of items, and I'll be brief. Let me come back to public clamor and key on something, Paul, that you mentioned earlier. Here we had a coordinated effort by the citizens and elected officials and employed officials with the city. There's no question that they were all reading from the same script. There's no question that the decision by the mayor to one day before the hearing to reschedule it so that we could get a broader audience. Enclosed with the record, I'm sure you've seen the letter that the mayor wrote to the city of Draper, trying to enlist their help in stopping development on that side. We have Facebook pages that are also part of the record.
I know there were comments about that, but is that material actually in the record? Those letters?
It is.
That
It is. We can.
That's part of what was presented to the decision maker in this case.
It is part of the record. While I'm talking, Aaron will find it. We've got binders of what's been identified as being on the record. So we've got a mayor who is writing a letter to Draper. So where in the record is that?
I couldn't tell you where it is in the PDF because when I created this binder, I organized it differently. It is in the record though. But I couldn't say the page number in the PDF off the top of my head.
If you'd like to, we can send this to you and to Paxton and tell you where it is in the record.
Fair enough.
Okay.
That works.
So we've got a coordinated effort by some of the council members and Mr. Bateman, who represented the group of angry citizens, and they were in lockstep with one another. So why do I bring that up? Well, we've all expressed our opinion of the Baker decision. I suppose I will add mine to what has been expressed here so far. As I struggle with the Baker decision, my struggle with that is the following. Why didn't it just come out and say the arbitrary and capricious and illegal standard is gone? I mean, if it is so low that you can have some basis or no basis, then just say it. Just say it. You can, on a whim, you can be arbitrary and capricious in your decision. And so if I think we would all acknowledge that we would hope that there would be some basis, that there would be some fact or issue that is reasonable that they could rely on in making a decision. And so instead, we've got the general plan, and we've already spoken about that extensively, how staff is saying that this meets with the general plan. We've got the fact that there's the long cul-de-sac. We've already established the fact that whether you go with the present plat or the amended plat, it's not like we're making anything worse. And so if you point to that as a reason, then you are being arbitrary and capricious. And then we've got the final argument that, hey, shucks, guys, you guys already have something you can develop. Never mind the fact that it would be impossible for you to take out hillsides to make that work. So where we have come to is what Paxton highlighted, and I'm a little surprised that he did. They just want to stop our ability to develop. There's no question. That is the basis. That's why they're in lockstep with the lawyer that showed up. That's why everything was pre-scripted. That's why we have somebody saying that the fire chief, they talked to the fire chief. Well, you know what the fire chief said? In order to approve these lots, this connection is required due to the length of the road with the relationship to the existing length of Lakeview Drive. That's from our fire chief. So if they're saying that they talked to the fire chief, well, they didn't hear him right, because that's what he put in writing. And so,
But you recognize that Baker says that there's a whole different standard for a subdivision amendment,
I do recognize that. Yes, I do.
and it's very discretionary. And
It is discretionary, but there has to be some basis. That's what I'm saying is the problem with Baker, is that you've got to say something. Otherwise, it is arbitrary and capricious. So if there's a whole lot of discretion, why didn't the Baker court just come right out and say, you can be arbitrary and capricious? Because then Alpine City would be off the hook. But that's what they...
You also recognize that I don't sit on the Supreme Court, so the grievances that I hold against Baker are really just personal grievances that you all have to hear.
Right, but Paul, you're the hearing officer, and you need to make a judgment call. And so if what you're being asked to do is just ignore it all on a whim, the city council can do whatever they want. All I'm saying is, if that's what the Baker court intended, they would have just said, get rid of the arbitrary and capricious and illegal standard. You can be arbitrary, capricious, and illegal. Go ahead. And I don't think Baker went that far. I fully acknowledge that case leans towards the city. But that's my concern. I don't think it goes as far as to say you can have any reason at all. You have to have...
I think it did say that. I think it said there can be good cause, but it's still permissive. The city doesn't have to approve a subdivision plat amendment, even if there is good cause. That's in the footnote. I think it's footnote 7.
Okay, so why didn't the court just come out and say you can be arbitrary and capricious?
I think it did.
You think in that sense? Well, respectfully, I disagree.
If I could
I think that's the way that the case reads. That's not to say that there's not room here to find that the city council didn't act arbitrary and capricious. I'm just saying, I think that Baker says they can deny it for, pretty much any reason if they find there's good cause. That's what it says.
Paul, if I could offer some insight here, and feel free to let me know if I'm if I'm missing on this. But as I read Baker, and I'm looking at the footnote that you had mentioned, and I'm just going to read here, even if the council had expressly concluded that good cause existed for the Baker's amendment, it would not necessarily have been obligated to approve it. So as I read Baker, that's as far as I interpret it. In other words, finding good cause does not compel approval. It doesn't get rid of the substantial evidence standard. In fact, Baker goes through 2.5 pages of substantial evidence analysis using that standard. If the statute, I don't think the statute says if they don't find good cause, they can deny it, and if they do find good cause, they can deny it. There would be a simpler way to draft the statute if that were the case. In my mind, and I'm happy to be corrected on this, I think these are standalone standards. I think that the Plat Amendment has that good cause language in it, but the other standard, the decision, which applies to more than just plat amendments, the decision still has to have substantial evidence. So to me, one does not eliminate the other. You have the standard in Baker and then a standalone, the substantial evidence standard for the decision. So I just want to make sure that that we're reading Baker to the extent that it goes and not further than that.
I understand your point.
Well, you've been gracious and we've been going for a while. Let me just key on a couple of things. You know, Paxton made the comment that we went back to traffic. Having lived with this forever, can I just say that there's no traffic issue? Look at the traffic study, it's part of the record. If that in any way comes into your mind as a basis, that was so conclusive that there is zero traffic issue. We spent a ton of money on that. The city was convinced by what it read that there was not a tax or traffic issue. And
the report said that it's not a concern, but I don't think you can say that there's zero traffic because there will be some traffic.
Okay, I will walk that back. There's nothing material. There's no concern. There's nothing material. So I appreciate your consideration this evening.
Is there anything else you have, Paxton?
No, this has been a good discussion. I appreciate it. Thanks for everyone's professionalism.
Apologize for me asking a lot of questions and maybe hopefully it wasn't too impolite as I aired my grievances, although I think you can rest comfortably knowing that however I might feel about Baker, I'm sure our good friend Bruce Baird had some very sharp words, and as much as Bruce likes to publicly say things about our tribunals in this state, I've only expressed my concern that I'm not sure that Baker was entirely well reasoned, and I will. Hopefully, you can appreciate that I have a greater ability to exercise strength than our good friend Mr. Baird, who I don't think has anything to do with any of this. He just was counsel on the Baker case, and I did hear his comments when the court decided that he was not pleased. So here's where we stand. I am going to take this matter under advisement. Hopefully you get a sense of what my thinking is. For me, the big sticking point is how to reconcile Baker, and I appreciate the arguments of both sides on that. While I think that the court said what it said, and I haven't pretended that I have the ability to undo that decision. I also I'm trying to I'm trying to figure out if arbitrary and capricious has any room in that decision, and I don't know that you can just erase that standard completely. At the same time, the legislature decided that a good cause standard is what it is, and it's permissible, and the Baker court said what it did. So that's my sticking point. I'm leaning towards finding that on the 2019 appeal, that the decision to not allow the red line, or to not remove the red line comment was arbitrary and capricious, because I just cannot reconcile how it's not consistent with the master plan when it shows a connection to Draper, but it is consistent with the master plan when it doesn't show that connection. When the 2007 master plan doesn't show any roads there, but I also don't know that that's a bar to the creation of new roads. If it were, then I think we'd have a big problem in a lot of cities. And that's where I hope at some point that the courts take an opportunity to interpret what section 109A 406 is all about, whether streets can only be constructed if they're shown on a master plan, or if streets can be constructed in a city or a county as long as they aren't prohibited by the master plan. I tend to believe that the latter is what the legislature intended. And if not, we would have a lot of problems in a lot of cities, including the one where I work, because we have subdivision plats that show new roads, and they're not always shown on master plans. So that's where I am. I hope to issue a written decision within the next 2 weeks. I did advise council that I may be, my schedule may be disrupted by an upcoming trip to the East Coast. And as it turns out, that is happening, despite the fact that getting on a plane when we have 4,000 cases of coronavirus diagnosed today is the last thing I want to do. But so I hope to have a written decision within 2 weeks. That's my target. I will press hard to do that, but it's going to be a little bit tricky with me losing a weekend. So if anybody else has any comments, any questions, ask them now, or if you have any concerns, questions, we have an email dialogue, but as has been the case to this point, I would ask council and city staff to continue to make sure that everybody is copied on those communications so that we don't get ourselves in an ex parte communication situation.
Sounds good.
Anything else?
Paul, given the fact that 2 weeks from today is Thanksgiving, should we just target hearing from you after Thanksgiving?
That's not a bad idea. And all of this presupposes that I don't end up on a ventilator. So if that happens, then you're gonna have to find yourself another hearing officer and do this over.
Okay. Well, thank you.
Fingers
for your
crossed.
help, and thank you, Paxton. Have a good night.
Likewise.
Thank you.
Have a good night. Thanks to everyone.
I just want to say I think that your arguments were both really good. They were on the salient points. This isn't an easy decision, and I know that there was a lot of angst in the community. Let me just say, I do land use. I didn't say that at the beginning, but that is what I do. I've been practicing land use law since 2001. I have been that attorney, and this was in my second year of practice. I was sent as the sacrificial lamb to a community where a developer we were representing was proposing something along the lines of 600 units on lakefront property in New Jersey, and it was a concerning moment for me. You know, I also appreciate when residents get concerned about the things that come into their communities. I think most people typically want to preserve the status quo. Sometimes that's not possible because property owners have rights to develop in accordance with what land use regulations allow. And has been stated, there's really nothing that hits home as much as where you live. And so I understand the concerns. And you know, I've been in these meetings where people show emotions, and you know, hopefully it can be productive. Sometimes people get carried away for whatever reason. At the end of the day, the decision that I make is going to be based on what I believe the law is in this case. And you know, I don't have any stake in this matter. I don't have any bias. Nobody here presented themselves as a New York Yankees fan, so I don't have to be concerned about having that kind of a bias. my goal at the end of the day is to make sure that I'm able to maintain my reputation as somebody who does good work in this field, and if this matter is appealed, that I look smart. And so, no matter what my decision is, I hope that everybody can appreciate that it's done with an eye towards what the law is, and that I don't have any preference in a particular outcome. And with that, I think we can all say goodnight.
Thank you very much.
Thank you.
Thank you.
See you later.
Thank you, Alpine City, for hosting us on the Zoom.